Hello, everyone, and thank you for joining this Use Laboris webinar. My name is Alessia Perez, and I will be facilitating the session for you today. Today's webinar will be given by a set of panelists, all from different member firms. And today we have lawyers from Belgium, Germany, India, and United States. Before we kick off the session, I will clarify a couple of points on the housekeeping side. If you have any questions throughout the session, you can use the Q&A tab to send your question to us, and the panelists will answer as many as they can in the dedicated Q&A session at the end of the webinar. You can, of course, also reach out to the panelists via email after the webinar. Regarding the slides, those will be available on our website along with the recording after the webinar. That's all for me. I will now turn over to Burkhard from Klimt HR Lawyers to begin the session. Go ahead, Burkhard, you are welcome to start.
Thank you very much. Thanks everybody for joining our webinar, which we have put on an early afternoon in Europe in order to be able to include both friends from Asia and from the across the Atlantic part of the world. I'm the current head of the Restructuring and Transformation group within Use Laboris, and we've been asked at the beginning of this year to organize a webinar, and what could have been more interesting than to have a look at the new world and maybe even new world order that has been coming to all us as a result of the Trump elections. That's why we choose this title, and we will not be talking about Mr. Trump in particular and only, but I think there are particular effects that we can all see or sometimes foresee on the world that we are working in, which is the world of HR and the world of restructurings and transformations. Since the question of applicable business models, change to business models and adaptation, changes to a footprint of a company on the global side, whether and to what extent to be more active in the United States, whether and to what extent to be more active, for example, in outsourcing projects with India, is something that is at the heart of a strategic thinking of HR representatives all over the world these days. And we wanted to shed some light on these questions. And I'm very happy to have participants both from the United States, from India, and from Europe. And this is also the way we want to go forward here. We would like to start a little bit in talking to my dear friend from Epstein, Becker, and talk a little bit about the current state of affairs in the United States, and then turn over to our friends in India, and to sum it up with a view to the European transformation and restructuring arena. Let me start with addressing Bill. Bill, if you would be so kind to introduce yourself briefly, because you are relatively new to this group. We are very happy to have you as a representative of a key US employment law boutique firm. And maybe you want to just give us a little bit of an insight into your work and in your practice to start with, if you don't mind.
Burkhard, thank you so much. Thank you for inviting me to participate in this program. Good afternoon, good evening, everyone. It's so nice to speak with you today. My firm, Epstein Becker, is a management side employment law firm. We have offices in 19 cities around the US. As Burkhard said, we are a boutique firm. We specialize in management side employment law. We do not have any overseas offices. Our focus is entirely on US and US employment law. And we look to many of you support for our clients where they require employment law related support around. It is my great pleasure to join this program.
Thank you very much, Bill. And I may disclose that we've been working together for at least 30 years, it feels. Yes. In a variety of matters, and that's why I think you are perfectly suited to help us a little bit through the jungle of United States affairs. We will not be talking high politics and high policy here, but rather down-to-earth realities. What I'd like to start with is very briefly about among the many papers that Mr. Trump signs every morning since he has been elected and coming to office. What is the good part of it relating to employment law matters? Is there any relevant legislation? I don't think you call it legislation, but it's decrees that have been signed that we should be aware of and that will change the world of employment law in your country?
Dorka, thank you. It's a wonderful question, and each day does bring new and interesting developments out of Washington that we are contending with. I will say, from a management employment law perspective, there are some positives, and what we are seeing increasingly in the United States is, as a result of our political polarization, it is very difficult to legislate. Congress often, and this goes back to the Obama administration, it's increasingly difficult to pass legislation. And so we have presidents, including Trump, increasingly legislating executive orders and through powers that they have to make appointments to the agencies that enforce our federal employment laws. So in response to Burkert's very good question about whether employers may see any positives, I do think that you will find that the agencies are tending to take more employer-friendly positions and interpretations of the law. Our Equal Employment Opportunity Commission, for example, which enforces many of our federal anti-discrimination laws, has been narrowly interpreting and even reversing some of the more employee-friendly positions taken by the Biden administration.
And this is, if I may come in, and this is happening overnight. So once the decree, just for us, because we need to understand, a decree's been signed, and then in an entire organization like the EEOC will then revert readings of the law, interpretations of the law, quasi overnight. Is that right?
It turns on a dime, Burkert. That is
right.
One of the great challenges here, is that you are not seeing a consistency and respect for precedent that, as an employer, a degree of certainty provides. And so this has been an ongoing challenge. Our US Supreme Court, in fact, has taken the position on a case decided before Trump took office that many of the agencies that do implement our employment laws require less deference by our courts because the agencies are reacting so quickly and differently based on the administration in power. So it does change quickly. The more employer-friendly EEOC, the more employer-friendly National Labor Relations Board, which governs union management relation, is taking positions that are much less pro-union than the Biden board took. The Department of Labor, narrower interpretations around joint employment, independent contractors, and the like. Our Federal Trade Commission, which had very broadly taken the positions that non-competes would be unlawful and unenforceable. You will not see that agency taking that position any longer. Perhaps the most dramatic turnabout has been with respect to issues around diversity in the workplace. In the wake of the George Floyd killing in 2020, many employers, including very large corporations, became very aggressive in diversity-related initiatives. Those initiatives are now in the crosshairs of the Trump administration. What's interesting is the fundamental laws here have not changed. Under US employment discrimination law, it has always been the case that you must hire and promote the best. Even where diversity was your goal in enacting policies that might afford certain preferences, those would not be defensible in the face of discrimination claims, quote, reverse discrimination claims, you might call them. But I think many employers were willing to take those risks to achieve greater diversity in the workplace. This is an area where many of our foreign-based clients face a challenge where in your respective companies, it may be lawful to set aspirational goals, certain percentage.
We call it positive discrimination. Is that right?
Discrimination. Thank you, Burkhard. That is unlawful in the U.S. It was unlawful pre-Trump, but we saw a greater willingness by employers to take some risks here, and we saw the agencies that enforce our discrimination laws less focused on those issues. Now,
that is interesting, and maybe we come to that just in a moment. One question to the administrative process. So if these agencies, which are federal agencies, change their guidelines and so on, can this be overruled, or does this affect the state laws? For example, the California laws on discrimination that are much wider than in the rest of the United States, or do they remain intact, or how does this intertwine? Nobody knows.
A wonderful question. So first, I would say that agency determinations can be appealed to our courts. So the courts will have a say here. And that process is one that if there are different opinions by different courts, may make its way to our U.S. Supreme Court ultimately. With respect to state and local law, Burkhard makes an excellent point. The federal laws that we are discussing here do not preempt, for example, state discrimination laws, local discrimination laws. Our political polarization is increasingly reflected in our state and local employment laws. So as Burkhard noted, California, very pro-employee, very broad anti-discrimination, leaves of absence protections and the like. New York, New Jersey, Massachusetts, the same. Those laws have not changed. So transgender status, sexual orientation discrimination, gender identity issues, all of those will be afforded the same protections that they were afforded under the Biden administration, under the new Trump administration. One of the challenges of doing business in the United States, so many of you kindly involve us in issues that your clients have around the world, and we'll get questions about the US position on a certain issue. And we always have to, unfortunately, push back and say, where are you located? Because the answer will differ if you are in one of our red states versus one of our blue states politically.
Yeah. And is there any general advice with regard to discrimination programs, or even the denomination of diversity departments? Would you recommend to the client to call it integration departments or something of the like? Is there a general recommendation?
Burkhard, again, a great question. I think what's critical is that your U.S. operations, we call it scrub, or do an audit of all of your policies around diversity-related initiatives, goals and timetables, affinity groups, employee resources groups, internship and scholarship programs, training programs, and the like, your data collection of demographic information for your employees, any sort of mentorship or training programs that would allow someone to advance with respect to their employment. Critical to review all of those things. We are seeing employers sit with a thesaurus and review their policies and change words like diversity, equity, and inclusion to welcoming and belonging and the like. And I think it may attract a bit less attention by our regulators, but I do think what's more fundamentally important is the review, the substantive review of both your external facing documents as well as your internal policies.
Oh, very good, yeah.
Critically important. And this too should be something you consider in the context of a restructuring. When you do your due diligence in advance of a restructuring, important to keep in mind now that previously perhaps less attention was paid to whether, for example, white males were being disadvantaged by some of your decisions. I think that should be part of the process.
Wonderful. Two small questions, just that have nothing to do with each other, but are of interest to us. One is there any particular laws that encourage business to be transferred to the United States? Do you foresee European or South American or Asian companies being required to particularly translocate work into the United States? And do we have is there specific advantages from this? That's one of the questions that I have.
Burkhard, it's a great question. I wish I had a better answer for you here. I do think that we are seeing the immigration border control is such a big issue with the administration, America First. So heightened scrutiny of visa holders and whether there are qualified Americans who might be able to perform those jobs, I think makes it a bit difficult in some instances for multinationals. I think as well with the uncertain tariff situation.
Yes.
I mean, certainly a goal is to increase manufacturing and production here. And so I do think that we will continue to see this uncertainty as the tariff and negotiation process occurs. So I think a political aspiration of the administration is to bring some of that work back to the United States, and they are taking aggressive efforts to do so.
It mirror images my second question. Is there any specific advice that currently you give to managers who travel into the United States? We've been reading articles in the papers that people have been stopped at the border because there was question about what actually they will be doing in the United States, whether they actually work in the United States, even if they're green card holders. Is there any specific advice that you would want to give to managers?
It's a great question. We have an immigration group here that
Yes.
has been advising our clients, and when we do have senior managers visiting the U.S., providing advice in advance just to make sure that things are in order and that there will not be an issue. And I think doing that diligence in advance of a visit, at least at the present time, is going to be critically important. I'm not seeing where a business visit yet by a manager has been an issue. It's more where someone might be coming over on a longer term assignment.
On a regular basis, yeah. Mm-hmm.
Yeah, exactly right. That there's likely to be the heightened scrutiny.
Yeah, great. Thanks for this insight. We'll come to the United States in a minute when we have a broader discussion. Thank you. I'm turning a little bit just across the world to India, and we have Suhas who joined us. Thank you very much, Suhas. And maybe you want to do the same thing, give a quick introduction to your firm and your position. We've been meeting in Delhi last year for a larger conference, and I'm really happy to have you here on this panel. Suhas.
Thank you, Burkhard, and pleasure to be here with my co-panelists here. And again, thanks for inviting me. This is a great discussion topic. I'm a senior partner in the Bangalore office of the firm. We are about 250 lawyers India-wide with offices in Delhi, Gurgaon and Chandigarh in the north of India. I'm personally based in South India in our Bangalore office, where we also have offices in Chennai and Hyderabad. We have an office in Mumbai as well. We have a couple of overseas offices, which are more rep offices for our India offices. These are in Chicago, in the US, and in Toronto, in Canada. We also have a full-fledged office in Dubai, where we practice both UAE law and Indian law. I'm based in Bangalore, as I said. I'm one of the founding members of our Bangalore office. So been with the Bangalore office for about 27 years. A substantial part of my practice involves labor and employment, specifically for foreign companies doing business in India.
That's where we are here. Thank you very much. I saw your very pretty offices. You just moved in last year. So, the reason why I wanted to talk about India in this specific arena is that there's not only old work, traditional work that we have to look into from a strategic standpoint, footprint standpoint, but in particular there is new kind of work when it comes to anything around artificial intelligence and IT, and we see a movement of R&D development, future engineering into India right away, rather than having it first established, like in the past when we established these things in Europe first and then automates them with the help of Indian companies. So can you tell us a little bit about how you see your foreign clients at the moment acting in India, and to what extent this business is developing, and give us a little bit of an impression and impress us. I was actually really impressed to see the large number of multinationals and what they do in India during the time I spent with you. So give us just a little flavor of what is multinationals currently doing in India in this respect. Yeah.
Sure. I think over the years, traditionally, it started as possibly outsourcing or offshoring of low-end work to India, perhaps in the work relating to call centers, and perhaps in the insurance sector, claims processing, and so on. So very low-end work was what was being outsourced. Over a period of time, we saw the industry mature, developed more towards R&D, software development, and so on. And I think subsequently, we see a lot of work in engineering design. And I'm told many aircraft manufacturers and defense contractors in the US now are doing a significant part of their design for aircrafts in India. So I think the industry has matured over a period of time. There is substantial availability of workforce, qualified workforce. And now with AI just taking over our lives, I think we will see a lot of work in the AI space. I was reading an article today by a very renowned Israeli author who wrote this book called Sapiens, and I would really recommend everyone to read this book. He said that AI development cannot be just restricted to the US and China. India has to be involved in this sector as well. And just like we saw, ChatGPT and DeepSeek being developed, Indian government is now promoting its own AI product. And we see a lot of AI use in our client companies as well. So I think the industry has matured to the phase where you will see new products and solutions that will be entirely developed in India.
And just give us a little flavor. When I was seeing you last year, we talked about for example, your data protection laws, and I understood that they are equally rigid, like in the rest of the world. So how do you cope with the tension between AI development and data protection issues? Is there a larger discussion in your part of the world, or how is this being handled?
Sure. So I think great question, Bakat. At the outset, I must tell you that as of today, our data protection laws are very minimal. But there is a legislation which has been enacted, but which has not been brought into force yet. The government has released draft rules under the data protection law. And the requirements are more or less as stringent as GDPR, and in some areas, perhaps even more stringent than GDPR. Now, specifically with respect to AI and use of AI, the union IT minister has been repeatedly making statements that India does want to bring in a special law for AI, and similar to what is there in the US and in China and in EU. And we have to see how they will implement the data protection law, how they will marry the provisions of the proposed AI law into the data protection law and so on. But as of today, what exists on paper is an advisory which was issued by the union government. And this was issued at a very particular time when India had its general elections last year.
Mm-hmm. Mm-hmm.
And there was fear that people would use deep fakes with political personalities and so on. So a one-page advisory was issued, which was a very stringent regulation. It used the word that it applies to intermediaries. So it was not really certain what they meant by an intermediary. For example, the advisory said that if you had any inconsistencies in the AI modeling process, you have to clearly demarcate what those inconsistencies were, issue proper disclaimers and so on. And when people started questioning this advisory, the government issued a statement that this advisory is not legally binding. So we have to see where we will land. But I'm pretty certain that in the next 1 or 2 years, we will have very stringent data protection as well as AI laws regulating AI.
And that is something to bear in mind if you take strategic decisions these days in transforming your business, whether it's in Europe or anywhere in the world, and transfer a good part into India, maybe because you think there is a looser regime of data protection law, and that's why I wanted to raise this, that in fact it may also be a selling factor from the Indian point of view, that it's an equal protection that is in place for the data that is being transferred. Tell me a little bit, if you are an international company and you have your R&D department in somewhere in India, and overnight you decide to launch a new project where you need 300 or 500 AI engineers. And I remember from the discussion with you that there was something you called rebadging. So how does it work? How do you get these people over? Is it very complex? And what if after a while you decide that, no, this project didn't achieve the targets, I want to have them transferred back, or I want to bring in new people? So how's the transferability of workforce is organized in these IT companies?
Great question, Barkat. I think initially I would say that there are perhaps two models that you can adopt if you need a sudden workforce for a new project or a new product. One would be, of course, tying up with what is called staff augmentation companies who have people sitting on the bench. We have employers who just have a lot of engineers on their payroll. And as and when demand comes from a client, the staff augmentation company will lend the employees onto the company which requires them. The second model, which I think you kind of alluded to, the rebadging exercise, is becoming very popular and very common in India nowadays. And the term itself just means that I'm wearing a badge, which is an ID card of one employer today.
Around my neck, basically. Yeah.
Around my neck. And tomorrow, I will be wearing an ID card or a badge of a completely different employer. And the transition, so to say, is kind of seamless. And the way this works is that, especially, it's very popular in the outsourcing industry. And it can work both ways. For example, the customer in the West may decide that he has a vendor in India who's rendering services to them. And the customer also has a captive unit in India. And the customer may decide that I want to bring the vendor employees onto the captive, or may decide that he wants to move employees from the captive onto the vendor. So it works both ways. Now, the process that is followed is that the employees are told that your customer, your work remains the same. You are employed by A entity. Tomorrow you will move on to B entity. There are a couple of ways to achieve this. We will take your resignation and the new employer will rehire you, perhaps on the same terms and conditions that were there in the
or better, or even better.
Or even better. Or the second option that has followed is that we will do what is called a transfer of employment, where the employee gives consent to being employed by the new employer, and the terms will remain the same. There's continuity in service. There's no break in employment. And retirement benefits will be calculated as though the employee joined the second employer on the original date of joining the first employer. Now, this is usually followed in, say, a business transfer agreement, where a business is sold lock, stock, and barrel via slump sale. But here we're seeing that the business, so to say, is just the employees. The employees are moving. There's no movement of underlying assets or underlying business even.
So other than under the European 2P model that we are all aware of, this the employee, him or herself, is the object and the target of the transaction.
Correct. Yeah. So this gives rise to a lot of issues. The first issue itself is, can the employees be considered assets or property of the employer to move from one employer to another employer without underlying assets or the assets the way that we know in the brick and mortar world, or underlying business being transferred. So about when I started doing these transactions about 5-6 years back, we were faced with this issue, and our client consulted a tax consultant who said, yes, they can be considered as assets. And so now the question is, how do you determine the purchase price or a transfer price? So the tax consultants have now come up with what is called a replacement value methodology, which means that, when in the example that you gave, I need 300, 500 employees to work on a project, and I need to bring them on board on my roles. What is the cost of hiring those employees if I did not go to a staff augmentation company or to my vendor to bring them on board to the captive? So that cost of replacing or hiring them afresh itself is the valuation. So now we're seeing valuations for such transactions where the employees are treated as assets, quote unquote, and a valuation undertaken to determine what is the transfer or the purchase price for these transactions.
And when I came back from India in summer, I thought, looking at transformation projects where we actually have to take footprint discussion about future lines of work, which are heavily dependent on artificial intelligence and the usage of artificial intelligence. Of course, the way of, the development of these products becomes key. And my reading was that you have very innovative and fast, with low transaction cost, means to transfer people on a temporary basis, project basis, and then retransfer them to a vendor or supplier and maybe take people with different skills for yet another project or for the continuation of the project. So it's super flexible. That's what I've seen from this model rebadging, which we were certainly not aware of before on this part of the hemisphere. In terms of unions, we never really understand how unions work in India, because I think from the past and also the way how India came into being and also the political systems, union play quite a role in your political system. How does this play out in the world that we've just been describing, in the technology world? Do we see unions? Do we see unionization movements? Or is that something that is rather limited to the old style economy of steel mills of the past? Yeah.
Excellent question again, Burkhard. So I think unionization has been somewhat less in the technology space. When the industry started, unions in the IT space were more or less just unheard of, because you were dealing with qualified engineers who considered themselves as white collar workers, then blue collar workers, and blue collar workers is where we saw trade unions and the like. But in the last 5 years or so, we are seeing some increased unionization in the technology space. So in our state and in our city, Bangalore, today there is an exemption in under what's called the Standing Orders Act, Employees Standing Order Act. And this law actually imposes what should be the working conditions of workers and so on. So the IT sector has an exemption which runs up to 2028. In the last 2 weeks, we have seen demonstrations by new unions in the IT space where their demands were, one, remove the exemption because the industry has matured. So they need to start enforcing and following all laws that are applicable even to the manufacturing space. And demand number two, IT companies are not really paying what is called overtime for working beyond the working hours. Now, a very simple example of what could be overtime in the technology space is that an employee works, say, 9 to 5, which is the regular working hour. And the manager says, there is a conference call scheduled at 8 p.m. tonight with the team in the US. So it's going to run for 2 hours. Be ready to attend this call. And the employee attends the call having worked 9 hours already. So is this subject to overtime payment or not? It's more or less always followed in the breach. If you read the law very strictly, overtime is payable. So the demonstrations we saw in the last 2 weeks made a specific demand that technology companies should start paying overtime and recognizing working beyond the permissible working hours as well. So my assessment will be that in the next 3 to 5 years, this industry will perhaps also see a lot of unionization.
Thank you, Suhas. And we can see, I think for the audience, by the way, you can always put questions into the chat and we try to chime them in as we move on. We can see how different parts of the world are trying to be as attractive as possible to attract business as a part of a global shift of power, but also a global recalibration of footprint strategies of companies, where to produce, where to do their R&D, where to manufacture, and where to service. And now we've seen 2 interesting examples that are left and right from our part of the world. And now we turn to Sophie. Thank you, Suhas. We turn to Sophie. And Sophie, I mean, the 2 of us, we are part of the old world, Belgium and Germany. I choose Belgium for this conference for a particular reason, because we have seen a larger exercise of a restructuring in Belgium recently. But Sophie, maybe you want to have a quick word about yourself and your firm to introduce to everybody here for the audience. Sophie.
Yes, thank you, Burkhard. Good afternoon, everybody, for those at least who are in our time zone, and good morning or good evening for the others. My name is Sophie Maas. I'm a partner at the Belgium law firm Kleijs & Engels. We are also like Burkhard's firm, an HR niche firm, so we are dealing with everything. I always call it from hiring to firing. I'm based in the Brussels office, but we have in Belgium 6 offices. Perhaps taking it a bit more broadly to have a look at what is happening on our part of the world in the middle between the two others that we have seen. And I think it's fair to say that Europe is definitely in a transformation or restructuring modus. We have seen a lot of restructurings last year. Some have been very much in the media as well, because they were not that easy. There was also a lot of social conflict that was going on with that. But I think more broadly speaking, in Europe in general, we see a transformational restructuring modus, which is caused by different reasons. And I think the first one is still economically, because we have a lot of sectors, and we see that from our clients, who are still very much suffering from the very high or volatile energy prices. So they need to reduce costs, and they need to proceed with workforce reductions in order to stay competitive. That is something we see with clients who have operations in all of Europe, that this is an exercise that they do in their different operations. Then secondly, as already indicated as well, we also have digitalization, artificial intelligence, etc., causing also a lot of restructuring work because of automation, because repetitive tasks are being replaced by artificial intelligence and so forth. But then on the other hand, we also see sectors really screaming for employees. That's kind of another dynamic that we have, but in more technical profiles. So I think that's also something that we see more technical. We are also in need to have more engineers, to have more people who are data analysts. And that is actually another cause that we now have also following what has happened in the new world with the new Trump administration. Europe has announced, and I think every member state has done so, to really invest in the defense industry at the moment. So I think there also I anticipate that we will need to have more and more people who are skilled in a more defense-orientated economy, because that is now the move that we see that governments are taking. And we also already see it with some companies, that they are really reassessing their strategic priorities that have been taken following the new world, the announcement, as William has already said, the announcement of the new tariff changes that may occur. So companies are seeing what the impact will be for their businesses. Especially my country is an export country as well. So all of this creates new questions, and also questions around, should we perhaps expand in the US and reduce operations here in Europe? So these are all set of dynamics that are happening.
And I think, Sophie, these things are happening already. I mean, we see announcements basically by the day, but I think in the back room of preparing and advising for transformations, we see a lot more coming in terms of complete refocusing of traditional industries. And now, when we choose Belgium, we had a look at a specific case, a plant closure that was announced by a German car manufacturer. Interestingly, choosing most likely not the easiest location and easiest jurisdiction to do a plant closure. During that case, and as a result of it, have there been any developments when it comes to the recreation of new work and the transfer of employees to companies that deeply require employees? Is there a tendency that you can see in these restructurings, that as a part of the social deal, people are being systematically transferred to new business?
at least that is something that companies try to achieve. But because within the framework, if we are dealing with collective redundancies and closures, I think one of the things that is different of perhaps of what is happening in other parts of the world, that is quite heavily regulated. We have information and consultation processes, so that takes quite a lot of time, and negotiations about a social plan. And a social plan is a plan that is foreseen to provide accompanying measures in order to help employees to survive after the restructuring. We see that especially that there is a tendency from companies at least to try to help employees to help them to find new employment, help them to reskill them, to provide outplacement, and all those kinds of exercises. But on the other hand, we feel that especially with the trade unions, the focus is still a lot on the money. Even if we see all those attempts to try to find other jobs, to try to give them training, etc., that at the end of the day, it's a question about money. It's a question about how much more do I get than what I am normally legally entitled to. And that is kind of the dynamics in a restructuring, because even information and consultation, it's a tactic in order to make sure that we have the highest social plan. And if we are, and that is a bit the dynamic that is happening in Europe. So it's definitely something we try to do, but it's still a negotiation.
And that may probably only work by M&A as being part of a restructuring process. That's at least my take in Europe, that rather than laying off people with expensive social plans, looking at selling at least part of the underlying assets. Now, this is the difference to what we've just heard from Suhas. We can just rebadge them, which would be nice, but it doesn't work under European law. But transfer them as a part of a deal, a transaction. We've been seeing this in the military recently, moving non-military business into military. Is there something similar that you can see in Belgium and beyond?
Well, actually not yet, but I think that will for sure come. It has been in the media that one of the plants that has been closed, that they're now the Ministry of Defense is looking at whether that site could not be used in order to produce munition, because it was in the automotive sector. So all the necessary the materials are there to do that. So this is currently being looked at. So I think for sure it will be a direction that we will see. And I'm also sure not only in Belgium, but also in France, because there has been announcements as well in France that they will heavily invest in their own defense industry. So then we will have questions around transformation, and either it's because companies will transfer their employees, but as you said, this is a bit more regulated in Europe than in India, because there we have QP legislation, meaning that employees transfer with their whole package. So they come to a new company with the backpack, I always tell it, with everything they have from the previous employer, and that you need to respect. But also it's a question about transforming, even if it is not accompanied with a change of employer. Also, if you as an organization want to transform your organization, then it comes with questions around how far can we go in changing terms and conditions of employees. And I think also generally in Europe, the rules are quite similar, that you cannot do that overnight and just say, well, as of tomorrow, we will do something completely different, and your salary remains, even if the salary remains the same. If you will change fundamentally the content of an employee's job, you will need consent. So this is also something I think that we will have questions around more and more, and which should be treated quite, I would say, carefully as well, because if there is no consent and you proceed with it, well, they can establish constructive dismissal. But if people doing that in a large way, you may be flirting with your threshold for collective dismissal, which then again triggers information and consultation. So it is something I think which needs to be looked at carefully and well prepared.
Perfect, Sophie. I'm just wondering whether there's any Q&A questions that we should address, and I'm asking my friends from the Youth Laboris office whether there's something that we should look into.
Yes, thank you, Burkhard.
Thank you. Yeah.
So we have indeed a question, and the first one is for Swash. What are your views on the proposed tariffs that is being proposed by the USA? How this may affect India?
Yeah, Suhas, go ahead. Tell us.
Okay, so I think basically it's a good question. President Trump actually called India tariff king. He said we are the king of imposing tariffs. And there is a proposal that he will start implementing tariffs on Indian imports into the US as of April 2nd. But at the same time, there is a high-level US trade delegation that is presently in India. And starting today, that's March 25th, till March 29th, they're going to be engaged in discussions on this very issue.
I think it's a moving target, isn't it? Yeah,
So, maybe the date may change, maybe it will never happen also, we don't know. But the expectation from the Indian side is that this matter is likely to be resolved through bilateral trade negotiations. India has already announced that it will do a rethink on tariffs imposed on imports from the US. So hopefully this will get resolved through bilateral negotiations. But if it doesn't, then it is expected that Indian exports in automobile, in precious stones, in agriculture, etc., will be subject to tariffs at the US end. As of now, I read that there is a tariff differential of about 8 to 33% on these products. So we'll have to wait and watch what's going to happen. I do like to use this saying, which is when the US sneezes, the rest of the world catches a cold. So if there is a sneeze from the US side, we really need to be careful how it will affect the Indian industry.
Unfortunately, currently there's sneezes both from the US and from China, so we have to cope with that. Bill, on the other hand, looking at what is actually happening on the US side, do you see upcoming inflation risks from the tariff discussion, and which may then affect US business that has just been transferred over? So maybe a trap in the end, or is that less of a risk at the moment?
Burkhard, it's a wonderful question. I think that we're taking a wait and see approach here. I do think Suha's comment of trade negotiations, perhaps averting the more draconian consequences of tariff battles is what we anticipate. We saw with Mexico, with Canada, the tariffs on and off, depending on negotiations taking place. I think that is the tool here that seems to be used by the administration is tariffs for negotiation purposes. And to the extent that those negotiations yield fruit, the hope would be that we would not have the inflationary consequences that are likely to otherwise result from increased tariffs globally that would result. So our markets here, as I'm sure all of you know, are reflective of this uncertainty. And I think that we crave stability with respect to these issues. So very much a wait and see approach from a US perspective.
Yeah, I'm more pessimistic, but let's see. And I've seen questions coming in relating to the EU. Sophie, I don't know whether you had a chance to see them.
No, not yet. Wait.
Maybe you can help, yeah.
Yes, I can help with this. The EU is already walking back on the excessive CSRD regulation. Are there similar plans, for example, for the pay transparency and the AI Act?
That is a
Well, yes,
difficult
indeed.
question, Sophie. Yeah.
Yes, yes, indeed. Well, actually, perhaps for the audience where it's referring to, so we have the CSRD, which is quite the regulation on of requiring companies to report on sustainability and their sustainability framework, which was quite extensive. And applicable to a lot of companies within the EU. Now, in end of February, there have been the proposals to limit the application and also to postpone the entry into force of this regulation, which is, of course, a lot of deregulation for many companies. So the questions that are being asked here is the same apply for the pay transparency. As far as I know, because of course I have not been able to look at all because that was being, the proposals have been submitted in what is called the omnibus proposals. I have not yet been able to analyze everything, but as far as I understand, the pay transparency was not included at the moment, but I think we will need to see.
At the moment, yeah.
Yeah, at the moment, because I think that the omnibus proposals is a first step that has been taken by the EU, which seems to indicate that perhaps they may go back on several of those regulations, which are quite heavy for companies in terms of administration, etc. I read that, for example, with the changes to the CSRD, that would represent a administrative or reduce an administrative cost for companies with 4.4 million euros. So it's quite the whole regulation and the new proposals that we see are quite important. So, but to be seen whether we will see others on the fields.
I believe, Sophie, you're absolutely right. I think the comfort we can give is it's very unlikely that there will be new regulations in unforeseen territory. I think with the new German government, maybe one day coming into existing, we don't really know, but I think it's going to happen. There will be a rollback on and a review of all unnecessary EU regulation. There will be a lot of pressure on the head of the Commission, a German politician in the party that is now coming to power in Germany. And I can imagine that at least there may be a postponement of the equal pay enactment, which is about to enter into effect next year. But I can imagine that this will be postponed even by 1 or 2 more years. I don't think they will take it off the table immediately, because that's a political question. But I cannot see that our new government, and they will then play a different role probably in Europe once they are in power, will allow any further disadvantages to our industry during this difficult transformation phase of the next 2 to 3 years. So I'm pretty positive about a postponement, rather, but not a complete abolition. Yeah.
Postponement and I think simplification, because the pay transparency now requires you to report on 7 statistics formulas. So I would think that they will simplify that and also exclude, like they have done with the CSRD, I would hope smaller companies from a lot of these obligations, because they're quite heavy for organizations.
Let's continue to be hopeful.
Need to see.
Let's continue to be hopeful. We're coming to the close of our webinar. Thank you very much for listening in. I think even though the 3 parts may have rather looked unrelated to each other, they're part of an entire strategic thinking for small companies, mid-sized companies and larger companies on where to invest, where to move new products, where to move your R&D in the next 10 to 15 years. And we wanted to help you a little bit in getting a better understanding of recent developments in major jurisdictions when you have a look at these questions. And we are really happy to take further questions. If you want to send us also after the webinar, we will be answering them free of charge, of course. And we hope to see you all soon on on all kind of different conferences and occasions. And we thank you very much for your kind attendance. And I'm thanking particularly to my co-speakers, to Bill in particular, who joined us here in Jus Laboris, Suhas and Sophie. Thank you very much for joining.
Thank you, Burkhard. Thanks, everyone.
Thank you very much.
Thank you.
Bye.
Bye.
Bye-bye.